Once again, I want to thank all of you at Holy Family for being here today, for Father Fan, for allowing this program. Hopefully it'll be the first of many. So if you like this program, let people know. We'll spread the word. And I think this is a very topical type discussion to have, given what's going on the planet these days. And so we're going to kind of get started with the program. So I want to ask you right now, do you have children, or have you ever had small children? And so the question I put to you is, if you've got kids, or you know someone that does, somewhere along the line, parents are going to leave those kids behind with a babysitter. And when they do that, they'll leave them with very specific instructions, and then maybe they go out to dinner. But what do you suppose is the first thing they do when they get to the restaurant? Well, they're probably going to call home, right? Because they're going to want to make sure that everything's going okay. And if they wanted to add to those instructions, they can do that when they call home. But the question I put to you today, however, is what kind of instructions will you want to leave behind when you're going away forever? Really good ones, right? Because what we're going to talk about tonight, as far as I know, you can't call home. That was one of my corny jokes, by the way. So if people were here, I might get a couple of corny laughs. Hopefully you're laughing at home. So good instructions have to do a few basic things. Since you can't change them, control your property. We'll go back one there. Forward one more. There we go. Control your property, giving what you want to when you want and who you want, when you want, the way you want. And that's probably the most important feature that we deal with our clients. If you want money to go to an 18-year-old for a college education and not a fast car, you better have some pretty complete instructions. And then we do this at the lowest possible cost. People want to minimize probate, taxes, and yes, legal fees. We're going to talk about all those costs today. We'll talk about 3 evils of estate planning: living probate, which is disability or guardianship; death probate, the one most people know about; and lastly, death taxes, the government's last chance to pick your pocket. And by the way, most people don't have a death tax problem today. So when I talk about estates that have taxes, if that doesn't apply to you, you're in good company. 80% of my clients do not have a death tax problem today. They're doing their trust primarily to avoid probate. So I don't want you to think that when we start to talk about higher estates that maybe that doesn't apply to you. And there's many areas of the law that come into play. But rather than bore you with all these different quotes of code sections, I'm going to tell you a story. The story today is about Bob and Pam. They're married, and we're going to say they have a $2 million estate. But whether it's a $500,000 estate, a $200,000 estate, a $1 million estate, or a $10 million estate, we're just using this as a benchmark because we can talk a little bit about taxes with this size estate. They own all their property together. Jointly. If you're single, widowed, or divorced, by the way, this program will apply to you. Bob is going to pass away in our example. And at that point, if you're single, widowed, or divorced, pay attention to that part of the presentation. They have some pretty common goals. The arrow circulating on the top there means that Bob and Pam want to control everything between the two of them. And then when the last one dies, they want to give half to Susan. She's down there on the right side of the screen. She's the perfect child. Maybe you've got a beneficiary in your estate, a child that's perfect. John's on the other side of the screen, not so perfect. I won't usually ask my clients right off the bat, do you have a John type child in your family? But it usually comes up. And if there is, you're going to plan for them different, right? And the only way the lawyer is going to know how to plan for them differently is if you're willing to share some time and some stories about those individuals. And that time is where the rub might come, because if you're paying a lawyer by the hour, you might not be willing to spend as much time sharing stories. So in my opinion, you want to have an attorney that will have some period of time where there won't be a charge to you so that you can share your stories and eventually get a plan that custom fits the individuals. Bob and Pam, we won't look at doing nothing for them, but we will look at holding assets in joint tenancy, using a simple will, and then lastly, creating a living trust. Joint tenancy is really a very simple concept. It kind of goes like this. Since both parties own 100%, as soon as one passes away, the other one wins. They own the asset. So if you understand that about joint tenancy, whoever survived gets it. You understand what we need to know about joint tenancy today. A will has to be in writing, and then it says where your assets go when you die. So what has to happen before a will can take effect? You have to die. So by default, then, a will can't do anything to help you while you're living. It only has meaning in one place when you die, and that's a probate court. So we're going to talk about probate in a moment, but first, Bob gets sick. Now, we don't expect him to die. We're just not exactly sure when he's going to wake up. So Pam's going back and forth to the hospital. Maybe that two-story house isn't going to work out for them anymore. They want to sell that home to move in something a little more manageable. But the house was either in joint tenancy, which means that both of their names were on the deed, or maybe the house was in Bob's name alone, and he wrote a will that said, when I die, my wife gets the house. Well, in either one of these circumstances, can Pam sell the house? The answer is no. She'd have to go to the probate court while Bob is alive to become his guardian. Let's look at how this works. It's a lawsuit designed to protect the person who's disabled. So we're trying to protect Bob, in this case, from his wife. So Pam goes off to court to try to become Bob's guardian. So that's the first problem, right? She has to hire a lawyer to go to court. Hopefully the judge allows her to be the guardian, but the judge will control that decision. Now, she wanted to sell that house. Who do you suppose makes the third controlling decision what that house sells for? It's the court. Once the house is sold, Pam has money to spend. Is she going to invest it? Well, the investments, again, will have to be approved of by the court. And if she's spending the money on herself or Bob, all those decisions need court approval. So for many of us, our home will be the largest asset within our estate, and the possibility of losing control through disability exists with either a will or with joint tenancy. Now Bob dies. So joint tenancy and the will operate differently now. Remember, whoever lives 1 second longer with a joint tenancy owns it. But if Bob had the house in his own name, planning to pass it to his wife under his will, then she doesn't get clear title to the house until the will is probated. So let's talk a little bit about death probate. On the death of it, with the joint tenancy first, everything goes immediately to the survivor. So Pam would own that property immediately. But if Bob did own it under a will, on the house in his own name, then that will would have to go to probate. So you can see from the first slide that most married couples won't have probate if they own joint tenancy at the first death. The probate would happen at the second death. So I'm showing you the worst case scenario here, but understand probate is typically a problem that affects the family left behind, not the surviving spouse. But it could happen in this case if Bob owned the house in his own name. So what is death probate? It's the legal process of transferring assets to the heirs. Sounds like simple, like living probate until we get into it. But the first problem with probate is it's there to pay off your creditors. When the lawyer goes to the probate court and files the will, the first thing they do is file notice in the paper for the claims of creditors. And that claim ad has to run for 6 months. Once all the creditors have been personally notified and it's been notified in the paper, then the attorney can go back to court and change the title of the assets into the names of live beneficiaries. In our simple example right now, we're trying to get that house, which was stuck in Bob's name, over into Pam's name. But as you can imagine, there could be some problems. Uncle Bob said he was going to leave me some money if I didn't get it. Maybe I'll file a claim against the estate and see if they'll settle with me. If you're in a second marriage, by the way, there's another type of will contest. Let's say that a couple comes together with family and assets from 2 different relationships. They're both widowed. Now they get together and they each have a will that says, I'm going to leave my assets to my families respectively. Well, under Illinois law, that will not necessarily make that happen, because under Illinois law, the surviving spouse or the children for a disabled surviving spouse can make a claim against the estate and receive at least a third of those assets, even though the will said, give it all to the children of the first marriage. Inventory appraise all the assets, finally make a distribution to the beneficiaries. As you can imagine, it's expensive. There's attorney's fees, executor's fees, filing fees, bond premiums. Of all the different fees that go into what we call probate fees, what do you suppose winds up taking the lion's share? It's legal fees. There's 2 ways that lawyers are paid to do this kind of work around the United States. Illinois lawyers are paid reasonable compensation. And though that's not a joke, usually when I do this live, I get a couple of jokes. What is reasonable? Well, let's take a look. It's whatever the probate judge says is fair. So a number of states don't like that law, which is what Illinois does, and they say we're going to pay the lawyers a percentage of the estate. And that average is about 4%. So if you happen to own real estate outside of Illinois, you might be in a state where the lawyers are paid a percentage. That real estate will create another probate needing another lawyer licensed in that state. So let's just say that you had this property in California and the market value was almost the same size as the mortgage. There was virtually no equity because of a drop in the market. Do you suppose that the lawyers in that case would be paid a percentage of 300 or a percentage of 1,000? Well, as you can imagine, based on the size of the estate would be a better calculator, so the law thinks. So in this case, at 4%, the legal fees would have been 12 times as much as the equity. And as a practical matter, the family would have walked away from this house and probably let it sell for back taxes. In Illinois, they probably would have wound up a little better. If you figure that it's 5% on average, it might have been a little more or a little less, but since it was just a house, maybe it would have been a little bit less in Illinois because lawyers don't charge by the percentage, they charge by the hour. So maybe that case would have been a little simpler in Illinois. Probate also creates a public record. I don't imagine anyone in the audience today wants to tell anyone what they have. Yet in probate, someone knows exactly what you have. There's an inventory of the assets. You look a little farther in the court file, which is public record, and you'll find a description of the debts. What were the bills to be paid? Your mortgage, your car payment, your magazine subscriptions. You look a little farther and you get the will. So the will has the names and the addresses of all beneficiaries. Not only do you know what that person had, you know who's got it. And if we don't want people to know that about us while we're living, we want someone to be able to figure that out after we're gone. This is not information searchable on the internet yet. But many states this is. Illinois so far is about a little bit behind. They don't make these, you have to actually go to the courthouse, but you don't have to be a lawyer to get that information. Average probate takes about 1 to 2 years. When you figure there's a 6-month claim period in there, you can see where a year would be pretty aggressive, especially if there's any kind of contest or complication. There's probate in every state, which we talked about already, and then that could run up additional costs and fees. Okay, so we've dealt with the fact that it's public. We've also dealt with the fact that there could be multiple probates. Maybe you've got that summer place in Wisconsin or Michigan, a winter getaway in Florida. And then there's death taxes. Now, once again, when I started the presentation, I mentioned that most of my clients do not have a death tax problem. So I'm going to tell you what the death tax issues are, because if you do have this problem, we're going to want to take care of that as well. But remember, most people are looking to avoid the first part of the presentation, which is probate, not the second part of the presentation, which is taxes. So there's 2 kinds of taxes, federal and Illinois. I'm going to take a moment right here because now probably anyone who came in late is here. I just wanted to let you know that if you did want to send a question to be answered at the end of the program, my personal cell number is the way you're going to do that today. And that number is 847-561-5030. 847-561-5030. Just send me a text message. That's how we'll get those questions today, and we'll get them answered at the end of the program. And by the way, if you just want to set up a meeting, again, you can find that evaluation on the website, or you can call our office at 847-940-7780. Let's take a look at the taxes, federal and state. So the Illinois tax starts at $4 million and taxes on its way up from there. So basically, we all get this coupon that eliminates the tax on the first $4 million. And when we die, as long as there's no more than $4 million in the estate in Illinois, there'll be no state tax. The tax rates are roughly 16%. Think of this as a coupon. And what do we know about coupons? They expire at some point. So this ability to leave $4 million only exists for 9 months after the date of death. Hold on to that thought for a moment because I'll come back to that in a minute. Now, the federal government also allows you to leave a certain amount tax-free. That currently is $11.58 million, and it's going up every year until 2016, at which point it drops. I'm sorry, 2026. In 2026, that exemption drops back to $5 million plus an index applied from 2010. So most people think it'll be somewhere around $5.5 to $6 million. The rate's 40%, however. So the federal rate, much higher. There's also another tax law you need to be aware of called the unlimited marital deduction, which is really meant to help people out, but it doesn't always do that. So this law says any money you leave to a spouse goes to the spouse tax-free, unlimited. But what would be the problem with that? Let's say that Howard Hughes died and with a lot of money, $5 billion, and he left it all to his wife if he was married. There'd be no tax. But this coupon, this ability to leave $4 million tax-free, 9 months after Mr. Hughes dies, that's going to expire. So Mrs. Hughes, let's say, lives for 5 years, and then she dies. Well, the kids will only have one coupon left, and that'll be Mrs. Hughes's coupon because Mr. Hughes's coupon expired 9 months after he died. So the key is, and I'll show you if you need it, how to save both of these coupons. Now, I want to make a point here. Most of my clients don't need 2 coupons. If they're married, 1 coupon is enough because they're under $4 million. These are the tax-free rates under the federal guidelines. And you'll notice 2020, there's your 11.58 number. And the sunset provision is what happens at the end of 2025 into 2026. So you're also allowed to give away gifts. So most people know that you were able to give away $10,000. That number's gone up over time. It's now $15,000 that can be given from one person to another person with no gift taxes. Also, the death tax coupon on the federal side, this $11.58 million coupon, if you've got a huge estate, and I actually have never had a client that needed this before, you could give away 11.58 and not pay the 40% federal tax, but then your coupon's gone. This isn't like a double dip coupon. You use it once, it's gone. If you use it while you're alive, your family can't use it again after you pass away. Again, those are pretty high level issues, not affecting many of our clients. Do you have federal tax or Illinois tax if you're below 4 million? No, but do you have probate? The answer is yes. Probate hits estates in Illinois at $100,000. So all you really have to do is own a house in Illinois or anywhere, as I don't know if you're all in the Shorewood area or not, but we looked today and your median household price was somewhere around $300,000. So there's going to be a probate just based on the area. So you're still stuck with living probate as well. So that has no factor with regards to the value of the house. If you're sick, someone's got to become your guardian. That's living probate. And death probate would be based on over $100,000. So the unlimited deduction in our example today with Bob and Pam means everything's going to the surviving spouse. There's no tax today, but 9 months after Mr. Bob dies here, his coupon is going to evaporate. So Pam now has the full $2 million, or if you had, a $500,000 estate, 250, then maybe she's got 500,000 at that point. But we're going to say in this example, it's worth 2 million. And then a spouse lives maybe for 7 years, and maybe that estate grows. So these are the average growth rates. And what you're going to see is that over the lifetime of a surviving spouse, because they think they're going to run out of money, they actually grow the estate. There's one less mouth to feed, and they don't want to rely on one of their kids in terms of where they're going to live, and they certainly don't want to go back to work and say, hey, do you want fries with that? That's not an option in retirement, right? So in our example, we're just using simple math. We're using a 7% growth rate. Pam lives 10 years. I understand 7% is probably not a good guaranteed rate you can get anywhere, but it does make the math simple. So if the estate was 500, now maybe it's 1 million. If it was 2 million in our example, now it's 400,000 or 4 million rather. 5. So Pam becomes disabled. So who's going to manage her property now? Joint tenancy is now gone, right? Because that stopped when Bob passed away. And a simple will. We know that a will can't do anything while we're alive. So what are we stuck with? Living probate. And who are we going to pick as the guardian? Now, Susan was the perfect child in our example, but John, he actually cleaned up for the hearing. You can probably recognize Robin Williams as the clip art we use there. But the bottom line is the court will make the decision on who the guardian is. It will not be Pam. And the guardianship will go on probably until Pam passes away. And then once she dies, that's when the will is going through court. And for those of you with estates anywhere from $250,000, $500,000, $1 million, $2 million, $4 million, whatever it is, that's when that will is going to take you into probate because you're over $100,000. The probate in our example today, there could have been 2 of them. That could have run up as high as $120,000. But what if there was no probate? We subtract Bob's probate, assuming that he owned everything in joint tenancy with his wife, right? So it all became Pam's. Well, then we're going to take that out, and then we're going to have Pam's probate done at 2%. So at that point, do we really feel comfortable that that's a number that we want our family to have to pay? 9 months after the date of death, the taxes are due. Again, this is an issue for about 20% of our clients. 80% of our clients won't have a tax problem. So let's summarize what we've talked about so far. Joint tenancy and a simple will. If we're trying to avoid living probate, both joint tenancy and the will have no effect while you're living. So someone's going to have to become your guardian if you're sick. Avoiding death probate on the first death. Well, that's the one bright spot of joint tenancy, right? But with a will, we know we're even going to have probate on the first death if we own assets just in our own name. And then on the second death, joint tenancy is no longer any help because it's gone. And the simple will, and by now the word will should equal in your mind the word probate. If you understand that wills lead to probate, you understand the first part of the presentation. Avoiding taxes, federal and state, both joint tenancy and the simple will has everything going to the surviving spouse. And if we do it that way, we know that we're going to lose a coupon and we're going to have taxes that are unnecessary. So for instance, if you needed that coupon and you couldn't use it, that extra value going to the government is at least $280,000 in just on the Illinois side for taxes. And it could be much more on the federal side. Other problems of joint tenancy, and I'm going to stress this because if I don't, I invariably get calls like, well, why don't I just, put my kid on my deed? When my mom died, I was on the house deed and I got it. It was no problem. Well, the problem actually may not have ever been discovered, but there could be a gift issue. Remember what I told you as far as gifts, you can give $15,000 away in 1 year without telling the government. Well, when you add someone's name onto the deed to your property, you're actually gifting them half of the value. And unless you live in a $30,000 house, half of the value is going to be more than $15,000. You're supposed to report that to the government. It may or may not get caught down the road. It will also create a capital gain down the road for the child who gets that home when it's sold. Again, may not have been an issue for you when you got it because the value is much, much lower in real estate, perhaps when your parents passed away, but times have changed. You can also wind up through joint tenancy passing property to someone who you never wanted to get it. So let's say a husband and a wife are married and they have everything in joint tenancy and the husband passes away, leaving everything to the wife. Have we ever heard of the surviving widow getting remarried? And now she outlives the second husband, maybe leaving everything in joint tenancy to the second husband. Well, what about those kids from the first marriage? Are they going to get any of those assets from their parents? Maybe yes, maybe no, but it's going to be up to the new person that married into the relationship because under joint tenancy, they may have gotten everything. Advantages, creditors. When you add someone on one of your bank accounts, for instance, a checking account, their creditors come with. If they get in a car wreck, they have to disclose that account. You might lose that account. You can't put control instructions with a joint tenancy. If you die and you put money in joint tenancy with a child when they were 18, are they going to go start a college fund? I don't think so. I think they're probably going to buy something like this. And the idea would be that if you want this money spent responsibly on a college education, you better have some good instructions. So I'm going to show you one example of a trust. First of all, I want to tell everyone out there that I'm not telling you you should have a trust today. The only way you'll know if a trust is right for you is to sit with a lawyer that you trust to go over your situation and advise you properly how to meet your goals. I want to put you on guard, however. There are a number of firms that still do what I call one-size-fits-all or boilerplate trusts. These are trusts that are virtually identical from one to the next, typically 10 to 12 pages long. I rewrite one of these very often. I would say maybe once a month. they come to me because they've seen a program or they talk to someone else and they say, we didn't really talk about a lot of the things that you mentioned, Ted. And when I see a plan like this that's boilerplate, one size fits all, I don't really ask them what did they pay, but I will ask them when did they find out what it was going to cost. And invariably the answer is, well, that's what the lawyer said they charge everybody, or they found out prior to a thorough consultation. And I want you to think for just a moment. If a lawyer can quote you a fee for a fixed fee prior to understanding your family, how likely is it that they're going to be doing something custom made for that family? I guess it's possible, but it's probably not very likely. Also, since these firms are typically doing things at the lowest possible price point, they don't give you funding assistance. So funding assistance is making sure that what you own is properly directed to your trust, either by naming the trust as a beneficiary or naming your trust as the owner. And by the way, your trust name isn't that hard to remember. It's your name followed by the word living trust. That's got to go on your accounts or beneficiary designations, depending on how you structure it. And a good lawyer will tell you exactly how to name beneficiaries. But that's part of our unlimited funding assistance to our clients included with every plan. If you don't have the trust properly funded, the assets are not titled properly, you could wind up with probate in disguise. And I think there's probably some pretty obvious reasons why you don't want a general practitioner doing this kind of work for you. It's a unique situation. You want something unique for you to meet your needs, wants, desires, and aspirations. The problem with probate is a problem of ownership. If you own something jointly, it's probatable on the second death. If you own it individually, it's probatable on the first death. Is there a better way to own property? For most people, the answer is going to be yes. Now, you're going to see this slide about a dozen times. This is a prototype slide that I made for Bob and Pam, and eventually it will describe their trust, and I'll tell you what all the circles mean. This is foreshadowing. But once the trust is created, again, it's given a name, your name followed by the word living trust, and that name needs to go on all of your accounts, and that's called funding. What might the instructions be? Well, while both spouses are alive, you might say, hey, if I'm sick, take care of me. But not just me, take care of my spouse as well. But let me stop for a moment. What if it's that second marriage and your spouse can take care of themselves? Take care of my dependents. Do we all have dependents? Well, some of us do. Some of us don't. And some of us have a lot of dependents. I'm sure there's people that are watching today that might be taking care of a parent, a child, and maybe even a grandchild. Who are your dependents? And maybe it's a little, maybe it's a lot, but if they are depending on you for something, you want to make sure that that's in your instructions. If you're sick, let the spouse take care of you and sign for you. That could be a trustee, but you might pick a child, you might pick a corporate trustee. This could be a bank that you really trust to make these decisions for you. It could be a CPA or a lawyer. We refrain from being trustees for our clients. We want to stand independent as an advisor, not as someone who's got a job when you get sick or when you pass away. Now, what about when only one spouse is alive? Well, then we might have everything going into the family or marital trust for the spouse, taking care of any dependents as well, minimizing taxes, and then picking a trustee that would be the one that would be able to sign for you. Now, on the bottom of this chart is where it's very uniquely crafted for individuals. So the yellow circle might be a subtrust created for a specific purpose. And this could be a single person, a married couple, and it really doesn't matter about the size of the estate. You might want things in a common trust to take care of kids while they're little, so that they're all getting the same benefits until the little one gets out of college. And then you're going to maybe divide it, but not distribute it because they're still too young. Maybe you've got grown children, and so you want to create a trust for them. Why? Because if they get divorced, you want the child to keep the money. You don't want it being split up in a divorce. You might want a trust for a grandchild. This might be to get them through college or something along those lines. Maybe you're afraid that your kids won't be able to send your kids to college. Charity. This could be, for instance, Holy Family Church. And maybe you want them to get it all at once. Maybe you want it to come out for a particular purpose or over a period of time. By the way, our law firm pledges 5% of our gross fees back to charity. That's actually how I got to Holy Family. There's a parishioner at Holy Family that hired us, and they wanted our give back program to go to the church. So I actually delivered that check to Father Fenn, and we discussed it, and that's what led to this program. So we're very much involved in giving to philanthropy and creating these bridges with various 501c3 organizations. Others might be godchildren, nieces, or nephews. But again, these yellow circles on the bottom of the chart now, you would never find them in a boilerplate trust. In a boilerplate trust, it would just say John and Susan, 50% each, boom, trust over. But most of our plans, I would say 90% of our plans, go on to provide a purpose after our clients pass away. The size of the estate, again, doesn't matter. And so if you're single, widowed, or divorced, or you have a non-taxable estate, you can do a single trust. And while you're alive, the green circle on the top there, basically that's your trust. Let's go back one slide. No, maybe not, go forward. I'm sorry, forward. We'll get to that again. So the green circle now basically let my children sign for me. And they're your trustees. But again, you might pick a brother or a sister or a corporate trustee. And then after death, now you see these yellow circles. And again, if you're a married couple or you're single, you're probably going to want to have a trust set aside when you pass away to protect those married children from losing it in a divorce, or actually a successful child from losing it to taxes when they die. And we'll talk about that a little bit as well. If you choose the trustees, then the court doesn't get involved in that decision. The trust has three positions: the trust maker, that's you; the trustees, those are your babysitters; and then the beneficiaries, these are the ones who get to spend the money. If you could only be one of the three, do you have a favorite? I think I want to be the one on the bottom of the list, beneficiary. What if you could be all three? And when we create a trust, and which is what we're going to do now, we're going to give Bob and Pam a second chance. We're going to replay the program over. This time they came to this workshop, they decided to create a trust. So in our office, our first meeting takes up to 3 hours. And at the end of the meeting, they decided they were going to make a trust. So they were the trust makers. They also wanted to control everything between both of them. So they were co-trustees. And they made it very clear to me that while they're alive, they want to be able to spend all their money. So they were the beneficiaries. So they occupy all three positions. And it looks like they have total control, right? And that's because they do. Once you create a revocable living trust, you have total control over your property. There's absolutely no new taxes. You'll file the same tax return using your own social security number. And since these are revocable, so we talk about living trust, revocable trust, inter vivos trust, it's all the same name. It just basically means that you can change it. Let's go back to our story. Bob got sick. What did Pam want to do? She wanted to sell the house. So let's take a look. Now let's say the house was in Bob and Pam's trust. Bob is highlighted now. So who's the trustee of Bob's trust? Pam. Could Pam sell the house, for instance, without attorneys going into court? Obviously she could, because she's the trustee. She doesn't need to become his guardian. She can use the money to take care of him. She can invest it how she feels is appropriate. And she would be a beneficiary of Bob's trust, so she could spend the money on herself as well. Bob dies. Does his trust avoid death probate? And the answer to that question is, were the assets titled properly? If they're in the name of the trust, then Bob's trust went from Bob's green circle down to the family or marital trust. And those are available to Pam. Again, without attorneys going into court, no executors, no time delay. There's no claims period, 6 months, no year to take care of it. There's no public record. The trust is completely private. The only people who will know about it are the people that you tell. And there's no probate in any other states, because as part of the Wealth Counsel network, I have attorneys in all 50 states. Wherever you own real estate, will be able to get that property transferred to your trust. What about taxes? Well, there's no taxes on the first death in our first experience, so there's no taxes here. And then that's either federal or state, but not because of the unlimited deduction, but because we're using that coupon. At the end of the presentation, if you need both coupons, I'll show you how we got that. Pam now becomes disabled. So now we're up on the top there. Pam's the lighted up circle there. Who's the trustee? She would have undoubtedly picked Susan, right? Because she was the trusted child. Without attorneys going into court, she can sell that house. She can take care of mom. And what if Pam's trust said, hey, send $100 a month to grandma because she has trouble making rent? Could Susan do that on behalf of Pam and her trust? Absolutely. In fact, she'd have to. She's called a fiduciary, and the trust says she needs to spend that money on grandma. and she would do it. Would the court have allowed that? Obviously not, because in our first example, the court was only protecting Pam, and giving money to grandma does not directly benefit Pam. Pam dies. Does her trust avoid death probate? And again, we go back to that answer. Do we have everything in the trust name? So if we have everything on the top up here, then when we go down, all the way down to the bottom there, then everything is going to be in these sub-trusts that we've created. These are now the yellow circles to protect the young children, to protect the older children from divorce, to protect the grandchildren, to get money to the charity and things like that. All those customized things that would be necessary no matter what size the estate is. All without attorneys going to court, no executors. You've seen these items several times now. What about the taxes? Well, by using a two-trust strategy for a married couple, which is what we showed initially, then you're going to double the coupons. So the federal coupon now goes up to 23.116. The Illinois coupon goes from 4 million up to 8 million. Again, these are provisions that are necessary for some, but not all. If you're not going to be above $4 million, then we don't need two coupons worth 8 million. So we might create a trust just to avoid probate. So the way that the probate is avoided, however, is that the money goes, let's go back one. We should have numbers on this one. So so Bob's money went, you'll see the arrows to the family and the marital trust, and that's when that coupon got applied right here in that middle section. So when that money went to the bottom from Bob's trust all the way down, no tax on 4 million. Pam started up here with a $4 million credit. You'll see her arrow goes all the way down to the bottom straight, and there's another $4 million coupon available at that time. So if you have a state under 4 million, then you can use just one trust on the top. It's going to be simpler. It's going to be easier. It's going to be less expensive, about $1,500 less in cost to do a single joint trust for a married couple instead of a double trust strategy like what we're showing here. And about 80% of our clients will do it that way. We talked about a number of these benefits, but let's go over them one more time. Benefiting minors, you don't want a kid to get money and blowing it on a fast car. You want them to use it on education. We talked about protecting money from a divorcing in-law. You want your child to keep the money. You don't want them to lose it in a divorce. By the way, we're getting close to the end of the presentation. So if you haven't yet, but you wanted to send in a question, please send it to my cell phone. That number is 847-561-5030, 847-561-5030. If you do want a consultation and you don't want to fill out the evaluation form, you can always call my office at 847-940-7780. But we'll show you how to fill out the evaluation if you want at the end of the program. Protecting money to benefit elderly people or people with special needs. If you leave money to a child that's getting public aid, it's possible that they lose the aid as soon as they get the inheritance. If we want to avoid that, we might create a special needs trust. Or perhaps you're giving money to grandma and grandma's memory isn't that great. Maybe you want that held in trust for your brother or sister to give it to mom when she needs it. Protecting from a spender. So, you've got a child like John in the family. You don't want him to lose everything in one foul swoop. So maybe you're going to parcel that out over, say, 20 years, with 1/20th going out every year starting when he's 65. You might think that sounds a little crazy, but we actually did a plan like that for a family with a ne'er-do-well type child. Protecting the estate from the creditors of your children. If you've got a lawyer, a doctor, or an architect in the family that are subject to liability, if you leave the money in their pocket, then that money could get lost in a lawsuit. If you leave it in the right type of trust, however, it's going to be protected. They could get to it if they need it, but it's never going to be subject to the claims of a creditor. You might want to get money down to your grandchildren as well. You don't want money going to an in-law. You want it going to your children or your grandchildren one day. We call that bloodline protection. And that can be a trust that stays around for 30 or 40 years after you die to make sure that when your children pass away, that money's still going down to another generation. Maybe you've got a successful child. And if you've got a child that's got a big estate already and you leave them, whatever it is, whether it's $200,000, $500,000, or $1 million, their estate got bigger, didn't it? And now if they live another 30 or 40 years, they're going to grow all of that money. And the money on top that grew, that money is eventually going to go to your grandchildren, but there's going to be some tax on that. So if we want to avoid the tax on your money as it one day goes to your grandchildren, Rather than add it to the estate, we might leave it on the side to be able to grow. But now from your trust, it could go directly to grandchildren with zero death taxes. And in the worst case scenario, we could be saving 56% in taxes because the Illinois tax 16%, federal tax 40%. So if you want to save money on taxes for your money, one day making it to your grandchildren, you might want to do a dynasty or a legacy trust. By the way, there's examples of those types of trusts at our website. If you go there in the information section, there's articles that you can read. And if you set up a meeting with us, we will send you a packet with some stories. What if your trust was around 100 years from now? Let me ask you a question. How many of you know the names of your great-great-grandparents? I don't. But if my great-great-grandparents had left a trust where I got a check every day, chances are I'd remember their name, and you might remember the names of your great-grandparents. But no one ever left any money, so to speak. And you might say, hey, Ted, nobody left me any money. This is a ridiculous example. And I will tell you that though they might not have left any financial resources, they did leave you something, didn't they? They left you an opportunity. So I'm the first person in my family to graduate from college, let alone law school. It's not because anybody left a lot of money, but it is because people left an opportunity. Each generation made it better for the next generation. Isn't this really the American dream? Trying to make it better for that next generation. So your kids and you might have something to leave behind that your parents didn't from a financial perspective. And if that's an important thing for you to spend some time on, these are the kind of people that typically work well with our firm. So here we go. So if we create a trust that your ancestors created, you probably know their names. I want to talk a little bit about how it works if you come to see us. Just a couple of the things before I do that, however, and again, if you wanted to send that question in, you're sending a text to 847-561-5030. The Illinois Trust Code came into play in 2020. Basically, it just made it more responsible duties enforced against the trustee, more fiduciary duties. The other thing that came into play that many people are talking about is the Secure Act. For the most part, this affects people in two ways. You used to have to take your required minimum distributions at basically the year after the year you turn 70 and a half. Now it's 72, so you've got a little bit longer before you have to take a distribution. So if you want to delay that tax a little longer, you can. And then the other thing that really changed is you used to be able to leave this money to your children and they would recalculate the required minimum distribution based on their longer life expectancy. But now they've said, nope, we're only going to calculate it down to 10 years. And in 10 years, we want all the income tax on that money that you saved for retirement. Because this was a retirement plan for you, not a retirement plan for your kids. That's the way the government basically looks at it. So basically, they're going to get their tax a little bit sooner. Like I said, our meetings take usually 2 to 3 hours at no cost to you. Most likely, you'll come to maybe Orland Park or St. Charles office. Go back. I'm sorry, I went too fast for you there. We'll review your current plan, estimate your probate costs and your taxes. Probate is going to be there for everybody. Taxes, maybe 1 out of 5, and design your instructions. So the idea is at the end of the meeting, we've got several options laid out for you, and we can tell you what those options would cost. If you decide to work with us, that's great. We would set you up with Danielle, the third attorney in the firm. We are a firm, by the way. It is not just me. There's 3 lawyers in the firm. I do all the initial meetings, and Robert's been with me for over 20 years. He does all the document preparation. And then Danielle, who's been with us since 2016, does all the document review and signing meetings. So you would meet with her on the back end. These meetings can also be done virtually. You don't have to come into any office if you don't want to. And in fact, right now we prefer that. We are an essential service, so we can meet you in an office. But if you don't want to, we can do a Zoom meeting. We can do a FaceTime meeting. We're actually preferring those at this point in time. It's a little less time for me in the car to get to one of the offices, and it's safer, I think, for everybody. So we're happy to handle it any way that you feel comfortable. If you want that face-to-face meeting, we are all wearing masks. We do have a screen between us. We're sitting more than 6 feet apart. You'll be on one side of the office. I'll be on the other side of the office. So we're out to keep everybody safe during this. If you want to sign up for that meeting and you want to just go to the evaluation form, I'm going to take you to the screen now to show you what that looks like. So again, if you are on a laptop, you'll be able to do this and you'll still hear me. So up on the top here of the screen, up on the top, yeah, you've gone to that, you clicked on that, you're going to see this screen. And so you already went there to get to the live stream, but if you go down a little bit further, you're going to see says click for the evaluation, or you can just go down and fill out the evaluation form. So if you go down just a little bit further, you'll see seminar evaluation. You're going to rate me as a speaker. So in there, you're going to want to put in a number. And then down below, and this is really important to me, hey, stop that. I don't have control over the mouse today. So if you want to rate comments, actually, if it was poor, tell me, and then tell me why, because we want to make it better the next time. So put the comments in there. We'll be reading all those comments. And then more importantly, if you want the meeting, check yes. And then if you check yes, don't forget, you got to go down a little bit farther and you've got to give us some way to contact you. So we need your name and we need your address. If you want to just skip right down and give us your phone number, that's fine. Michelle can reach out to call to schedule your meeting. Typically, we schedule meetings around the hours of 9 and 12 and 3 o'clock. If you want that scheduled via email, give us your email address as well. If you want to tell us what your plan currently is, you can fill that out, but that's completely optional. We will follow up with you from there, and I will be talking to you about those items when we see you directly. So once again, that's available if you're on your laptop right at the top. If you want to go to that form, oh yeah, and you can get to it at any time once you've got that address, or you just go to cusack.com in the form section. You'll find an evaluation as well. They're kind of all over the place. Easiest thing to do is just pick up the phone if you want to do that, and typically Robert will pick up, or you'll get our voicemail system. And if you want to call that number again, it's 847-940-7780, and we're happy to schedule your appointment from that point. Once again, I want to thank Father Fenn and Pam for inviting me to be here today to talk to you at Holy Family. And I'm just going to see if anybody sent in any questions. And I'm not seeing anything, so I must have been so explanatory today that you didn't have any questions. But if you do have questions and you want to talk to me before you come into your consultation, you can talk to Michelle. She'd be happy to schedule a time for us to talk rather than playing phone tag. She'll schedule a time for us to discuss what questions you might have before you come into the meeting. Otherwise, bring those questions in, and I'd be happy to take care of you at that point as well. So I'm going to tell you what I pretty much tell everybody when they leave one of our meetings these days, and salutations to our letters, and that is, please, peace be with you, stay safe, and if you decide to come in to see us, that's great. If you decide to see another lawyer, please take some action and make sure that you get your estate plan in place. God bless.